Hello and welcome everyone to our webinar today, Protecting Your Small Business's Intellectual Property. I'm Jolene Carey Pace, the Program Coordinator at the Wilkes University Small Business Development Center. I'm thrilled that all of you could join us this afternoon. Before we begin, I would like to thank Mary Jo Kishel of Rosen Jenkins and Greenwald for partnering with us and sharing her presentation today. Just one quick note to please put yourselves on mute so that we can avoid having any background noise. Also, as we go along, you can type any questions that you might have into the chat box, and there will also be time at the end of the presentation to ask any questions you might have. And now I will go ahead and turn the program over to Mary Jo. Thank you.
Thank you, Jolene. Jolene, before I get started on my presentation, I'm just wondering, oh, never mind, I see it. Okay, I thought I had lost some functionality. All right, well, I'd like to thank everyone for attending this afternoon. I will be talking to you about trademarks, service marks, and copyrights, which are often one of the most valuable assets that a business has. For instance, the Nike swoosh, when it was created decades ago by a graphic design student for the Nike company, which was then known as Blue Ribbon Sports. And I'm sorry, I think, yes, okay. It was, it had no value and no appreciable value ascribed to it. And the Nike company paid $35 for that swoosh to the student who designed it for the company. And then, of course, through their marketing efforts and quality products, the swoosh has become an extremely valuable mark. So I will walk you through the information that will be necessary in order for you to navigate this area of the law. And first, I'll discuss the factors that you should consider when choosing a mark. And then I will explain how best to protect your mark. And I'll also walk you through a little bit of copyright law, because copyright protection can often be more comprehensive than the protection you would get for a trademark or a service mark. And the same design can be a trademark, a service mark, and a copyright all at the same time, and I'll explain that. So first, I'm going to start with some fundamentals, and I apologize if you already know these things, but I just want to make sure that everybody's on the same page. There are two kinds of marks, trademarks and service marks. Trademark is used in connection with the sale of a product or goods, and it has to be either located on the product itself or in close proximity to the product. So on the packaging or on a label, or even on a display that contains the products. And then a service mark is a mark that is used in connection with the sale of services, and service marks are used in marketing materials because services obviously are not tangible, so you can't put the mark on the service. Trademarks and service marks are used to create brand identity, to indicate the source of the goods or services. Whereas a copyright is something that has somewhat of an artistic expression to it. And if you have a design, then that design, if you're using it to sell goods and services, it will be a trademark and a service mark. And it will also, if there's not enough of an expression to it, it will be subject to a copyright as well. A trademark or a service mark may be comprised of only words plus a design, or only a design. Copyright, of course, would only be the design portion of that. And there are other types of works that are subject to copyright, and we can talk about those later. First, I'll talk about trademarks and service marks and how to choose one, and factors to consider when you're determining what to use as your mark. From a legal standpoint, the marks that are going to give you the most protection, meaning you will have the greatest chance of obtaining the exclusive right to the use of those marks, and you'll be able to prohibit third parties from using your mark, is if you choose an arbitrary, random, or fanciful mark. Something that that isn't just descriptive of what you're selling, product or service. Because if you're going to take a mark out of the public domain, the law is designed to only allow you to do that if you're not, number one, just using the generic words for what you're selling. So if I was going to sell sharp yellow pencils and I wanted my trademark to be sharp yellow pencils, then I would not, I could use that, but I wouldn't be able to bar anyone else from using the same exact mark to sell pencils. And I certainly wouldn't get that registered with the Patent and Trademark Office. Very often, because those are just generic words. Very often people will choose descriptive terms for their trademarks and service marks because that's good from a marketing perspective. And depending on how descriptive they are, you may or may not be able to take those words out of the public domain. Often, even if you have descriptive words, which is good from a PR perspective, if you use, say it's a slogan, but it's descriptive of what you're selling, you use that to sell your product or your service continuously for 5 years. Your mark may be deemed to have obtained what's called secondary meaning. That means that the public has now come to associate those words with your product or service. And so you should be able to take that mark out of the public domain and have the exclusive right to use it. But you don't get into that at all if you pick a fanciful or a random mark, then you don't have that problem. So it's best to pick an arbitrary random mark and avoid a descriptive mark. And examples of strong marks are Exxon, Texaco, Xerox. Before those companies marketed their products and services under those marks, nobody would have had any idea what those marks stood for. And so from a legal standpoint, those are the strongest marks. From a marketing standpoint, it may be more of an uphill battle to get the public to associate your mark with what you're selling. You should also avoid terms that are just identifications of geographic regions. If you do include those in your mark, say it's NEPA, I don't know, NEPA something or other, printing, anything, NEPA paper products, well, that would be extremely generic and geographically identifying, but you can use a geographic identifier, but you will not have the exclusive right to the use of that identifier. So, and you see, of course, NEPA with other words all used as marks all over the place, because anyone who is marketing in a particular geographic region should be able to use a geographic identifier to describe what they're selling. So you're not going to get the exclusive right to use that. Also, similarly, if a mark is primarily merely a surname, you will not obtain trademark or service mark rights in that mark, because everyone should be able to use his or her surname to market his or her business. So you won't be able to take that out of the public domain unless your mark obtains notoriety. For instance, McDonald's. Everyone associates McDonald's with the fast food chain. And depending on what you were using McDonald's for, you may or may not, even though it's your last name, you may or may not be able to use that, because you could, if you opened a restaurant, that could indicate that you are somehow affiliated with the national chain, then that would serve to confuse consumers, and that would not be allowed. Once you have identified a mark, whether it's words or a design or a combination of the two, that you're interested in using in your business, you should, before you use the mark, have a search done. When a client comes to me with a mark that it's interested in using, the first thing I do is I go onto the records of the Patent and Trademark Office, and I look up the mark to see if there's anything that would really cause great concern, and knock the mark out right from the beginning. If I don't find anything like that, there's nothing of concern on the website of the Patent and Trademark Office, then I recommend that we order a search. There are a few companies. There's one that I use very frequently. It's a Boston-based company, and that company will do a search, a more thorough search on the records of the Patent and Trademark Office than an attorney could do. And they will also do a search on the registries of all 50 states, because you can register a mark at the state level. Your rights will not be as broad as if you registered at the federal level. And they do common law searches electronically as well. So the Boston-based company will do an electronic search of Dun & Bradstreet records, trade journals, domain names, and websites to see whether or not there are any confusingly similar marks, not only that are registered at the federal or state level or pending registration, but also whether there are any marks that are simply in use that are confusingly similar to yours. And that's very important, because federal registration is not required in order to obtain trademark or service mark rights. You can have common law rights, and your common law rights can extend throughout the country if you use your mark in interstate commerce throughout the country. But there are benefits to registering, otherwise no one would do it, and I'll get to those in a moment. But I just wanted to mention that when you have a search done on your mark, you're looking for marks that are confusingly similar in appearance or identical in appearance. And the goods and services don't have to be identical. The goods and services that those other marks are used for they don't need to be exactly the same as your goods and services in order for there to be an infringement if you start using your mark. The goods and services simply need to have some relationship to yours or some perceived affiliation in the marketplace, so that if you started using your mark for whatever your business is, someone would be likely to, if they saw your mark, to think, oh, that must be the same company as that other company where I bought some other product which has some sort of relationship to yours. Maybe, one is, maybe they're products that are used together, or they're both construction type services, or one is a construction service and the other is a cleaning service, but they somehow could fit together. You need to be aware of that when you're reviewing your search, and the searcher is would be aware of that too, and would include all of those marks for related goods and services in the search results. But back to what I was saying before about the benefits of federal registration. Even though you have common law rights, as soon as you begin to use a mark in interstate commerce in more than one state, you automatically have priority with regard to that mark over all subsequent users. But there are benefits to registering. First of all, the registration is an official documentation of ownership. And if you ever needed to prove that you owned the mark, it's certainly, it carries a lot of weight, and you are presumed to be the owner of that mark if you have a federal registration. Also, the registration is public notice that you're the owner of the mark. So if anybody went onto the website of the Patent and Trademark Office, they would see there a notification that you own the mark, and that often dissuades third parties from embarking on their own use of the same or a similar mark as yours. Another benefit of registration is that it will prevent federal registration of confusingly similar marks. So if you register your mark and then someone subsequently decides to try to register the same or a similar mark, the Patent and Trademark Office will not allow them to do that. You'll also obtain protection from competitors nationwide if you have a federal mark. You will be deemed to own the exclusive rights nationwide to your mark, except for prior users. If someone used their mark before you, but they never registered, and you're the subsequent user, but you register, you'll be able to stop that prior user from expanding their use beyond the geographic region in which they use their mark prior to your registration. So you can stop them from expanding their use. You can't stop them from using the mark because they're a prior user. But if they don't register and you do, you can stop them from any expansion of the use of their mark. So that's why it's always good to register, and register early. And you'll also reap benefits internationally. If you register and then you're interested in selling your goods overseas, a lot of countries will allow you to register your mark with them on the basis that you're already registered in the United States. And the United States does that as well. If someone is registered in another country, they can obtain a registration here in the US federally on the basis of their foreign registration. Another benefit to registering federally is that it will allow you to gain access to federal court in the event that you believe that someone is infringing on your mark. And once you get into federal court, if you have that registration, you will, it will afford you the advantage with respect to the burden of proof at trial, because you will be presumed to be the owner of a validly registered mark, and the other party will have to prove otherwise. So it puts you at a distinct advantage if you do have to go to court. The Lanham Act is the federal statute that governs trademarks and service marks in the United States. And Section 35 of that act provides for monetary damages, an award of monetary damages for trademark infringements, and also in the event of unfair competition, and if there is a willful trademark dilution. And that is when someone intentionally, knowingly uses an infringing mark in order to, or it could be identical or confusingly similar, in order to dilute the goodwill that you have built up in your mark and the brand identification that you built up. So you're able to get money damages if you have a federal registration and sue under the Lanham Act. And you may actually be entitled to treble damages under the Lanham Act, and that is 3 times proven damages, which is very nice and is certainly a deterrent to would-be infringers. If you lost business, if you can prove that you lost business due to the infringement, and there was an intentional use of a known counterfeit mark, and that's Section 117B of the Lanham Act, 1117B. And you'll also be entitled, if you register, to statutory damages. The law changed 8 years ago to allow for statutory damages for a trademark or service mark infringement. So instead of having to prove your actual damages, which sometimes is quite difficult, the court may be able to, it would be able to, if you registered federally, award you statutory damages. And in order to get statutory damages, in addition to having a federally registered mark, the infringing mark would have to be almost identical, and the infringing product or service would have to be listed in your federal trademark or service mark registration. So, so that's a nice benefit to registering federally. Let's see. Also, I already talked about enabling registrants to stop prior users from expanding the use of their mark. The final benefit to registering federally is that it really gives teeth to a cease and desist letter. So if someone has infringed on your mark and you hire an attorney, most likely to send a cease and desist letter, or you send one yourself, and you assert your rights to the mark in question, there's certainly more force and effect to your letter if you have a federal registration, rather than relying on your common law rights. If you're simply relying on your common law rights, then the other party may say, well, I have common law rights too, and I don't believe that you were using your mark before I was, and then you may have a more of a fight on your hands, rather than being able to say, I have this federal registration. The registration says when your date of first use was, it will say when your date of first use anywhere was and when your date of first use in interstate commerce was. And and it will set forth really the basis for your claim of superior ownership to a mark. Although you always want to, before you send a cease and desist letter, check to make sure that you are in fact the first to use the mark between you and the person you're sending the cease and desist letter to. Because if they use the mark before you and you haven't, your mark has not achieved incontestable status, and that is after 5 years of continuous use and registration with the United States Patent and Trademark Office, somebody could turn the tables on you and say, oh, thank you for telling me that we're using confusingly similar marks. I actually have the prior right to the mark. So, so there are some twists and turns under trademark law, and I'm happy to help you navigate through those. But it is always best to register. And then there are certain filings that you have to make between the 5th and 6th years after registration in order for your mark to really become incontestable, virtually incontestable. It won't be incontestable if there's any fraud involved, of course, but then you don't have to keep looking over your shoulder. You'll know that you have the valid right to that mark. Okay, if your mark consists of a design or a logo, then you can achieve a very broad protection under the Copyright Act of 1976. Even without registering, similar to trademarks and service marks, you will have common law rights as soon as you reduce your logo or design to a medium of tangible expression. So as soon as you put keystroke to your computer or pen to paper, you will have common law rights in whatever it is that you've created. But you will not be able to sue anyone for infringement. So you will not be able to pursue a legal claim unless and until you register your logo or design with the Copyright Office. So the benefits of registering with the Copyright Office are, number one, it'll provide you, akin to the trademark service mark scenario, with a public record of your ownership. You will be presumed to be the owner of that design or logo. And as I said before, you have to register in order to be able to file a lawsuit for infringement. The Copyright Act also provides you with eligibility to be awarded statutory damages in the event that someone infringes, as well as attorney's fees and court costs, but only if you register either prior to the infringement or within 3 months after publication of the work. And so there's an incentive to register your copyright as soon as it's completed, as soon as you know that that's the logo or the design that you're going to be using, because statutory damages are extremely beneficial in the event that it is difficult to prove what your actual damages are. You may not know exactly what business was diverted from you because somebody used an infringing mark. You know some business was diverted from you, but you don't know exactly how much, and so you have no way of quantifying that. So that's when statutory damages come in, and the court then can award statutory damages for each work of yours that was infringed, but only if you register, and only if you register within that time period. A copyright owner also may participate in the U.S. Customs and Border Control protection. Also, service mark and trademark registrants can participate in the Customs and Border Control protection as well. And so if you register federally your copyright or your mark, the government will attempt to stop the importation of infringing goods. If something, infringes, it bears your mark or something extremely similar, or it's a knockoff of your copyrighted product. And just as in the trademark service mark realm, a registration of your copyright will lend credibility to a cease and desist letter in the event that you need to demand that someone stop using your logo or your design. So whereas if you have a logo or design and you register it as a mark, trademark or service mark, you'll be able to stop infringers from using that design in connection with the sale or provision because it doesn't have to be a sale for compensation, but you'll be able to stop a third party for using the same or a similar mark in connection with the provision of confusingly similar goods or services. But if you also register the logo with the U.S. Copyright Office, then you'll be able to stop anyone from using in any way, reproducing, displaying, sharing, or copyrighting that logo, regardless of whether or not they are using the logo in connection with confusingly similar goods or services. They simply cannot do anything with that copyrighted work unless you give them permission. And that is the case whether you register the copyright or not, but you will not be able to pursue a legal claim unless and until you register. So, although federal trademark and service mark common law rights arise upon use of those marks in interstate commerce, and copyrights arise upon creation of an original work of authorship that is fixed in a tangible medium of expression, registration can greatly enhance those rights. And in some instances, it's absolutely necessary. So I thank you all, and I invite any questions, excuse me, that anyone may have. That's the end of my presentation.
Mary Jo, it's Dorothy. I just have a quick question. Lots of times I hear about provisional patents. What does that do for, any of these?
Well, a patent is a separate category from trademarks, service marks, and copyrights. A patent is something that has a utilitarian aspect to it. So it has to have some functionality. And actually, software, computer software, can form the basis of copyrightable material as well as patentable material. Because once you put, once you initiate a keystroke, you automatically have a copyright in the work that you've created at that point. And then in every point thereafter along the way until you have a completed work, your software, and then you have a copyright in the whole. For the patent, you will not have, the software is patentable as long as it's unique and original and has and serves a function. There's some functionality to it. But you would have to register your patent in order to have rights. In order for it actually to become the subject of a patent, you'd have to register the patent. Registering provisionally is a step before a permanent patent, and that is it's sort of a placeholder. So if you want to be able to prove when you first created, in my example, that software, you can file a provisional patent, which can be done pretty quickly and much less economically than the full patent process. And that will sort of hold your place so that if someone else comes along and tries to file a patent for the same thing or for something that's too similar to yours, so that they both would not be allowed patents together, only one or the other, that one, yours would be cited against that one would not get through. So it's a placeholder on your way to getting a permanent patent, but it is not itself the permanent patent.
Thank you.
If there are any other questions, feel free to unmute yourself or type a question into the chat box.
Hello, I have a question.
Yes.
I understand that titles, for example, of books and movies are not copyrightable. Is that true?
Yes, a title by itself would not be copyrightable because there's not enough substance there. And
I see. And
I've
how
gotten that
about
question several times.
How about if you were to do a book series? For example, there's Penguin Publishing. They do public domain books under the moniker of Penguin Classics. Is something like that copyrightable?
The moniker itself could be the subject of a trademark as well as a service mark. So their service would be publishing services, and if they market those publishing services under that moniker, that's a service mark. And then if the series of books are also marketed under that same name, then it's also a trademark. And you can register a mark as a trademark and service mark all at the same time in one application. But it wouldn't be a copyright.
And how does like a domain name tie into this? Can you copyright a domain name?
Let's see. I have not no, you can't copyright a domain name. Because there's not enough substance there. People have in the past wanted to copyright slogans and phrases. I remember somebody wanted to copyright, this is a long time ago, something like Think Pink, or I don't know, the
Right, yeah.
Yeah, Pink Fridays, or anyway, there's not enough substance there to form the basis for a copyright. And that's the same thing with a logo, quite frankly. If you only have a few lines, it just may not be enough. There may not be enough artistic expression there to be copyrightable. Right. But it could still be the subject of a trademark or a service mark if you're using it that way to market your product or your services.
I have one other question. Suppose one was to go through the process of registering and so forth and so on, doing everything by the letter, and then someone does infringe and a claim situation came up. Typically, a lawyer handling the claim, would that be something you have to pay up front for the lawyer, or is that a contingency, or is that up to the individual lawyer to go
Really
after
up-
that person?
Yeah, that's really up to the lawyer. Generally, those cases are not taken on a contingency fee basis. But I could envision situations in which they would be. If the case was, if the potential recovery merited a contingency fee basis, if it might be large enough to merit a contingency fee basis. But generally speaking, an attorney would treat that as chargeable on an hourly basis. And
Okay,
yeah, it would generally start with sending a cease and desist letter.
right.
Yeah.
All right, well, thank you very much. You had some very good information in your presentation today.
Well, thank you for your questions.
There is a question in the chat box. Can a curriculum manual be copyrighted?
Yes. A curriculum manual is normally contains enough of an expression of ideas to be copyrightable. I think, for instance, I think I don't know if it was the white pages, but I think at one point the white pages were considered to have enough of an expression to be copyrightable. And that, I think, certainly has less of an expression than would a curriculum manual. So, and it's not, you have to keep in mind, it's not the substance of you know, in this case of the manual, that would be the subject of the copyright. It is the way the substance is expressed. So the way everything is arranged, and if, you know, say for instance, you're talking about a novel, it would be the way all of the words were arranged. And so someone else could write a novel with the same kind of plot and the same types of characters, and this, you know, the storyline is all the same, but it's expressed completely differently. That's fine. That's not a copyright infringement. Also, it is conceivable that two parties could come up with the same exact work. Let's say a poem, because it's not as likely for a whole novel, but let's say a poem or a logo or a design that's exactly the same, as long as they're both original works of authorship and one did not copy the other, then they're both subject to copyright protection, full copyright protection, and they could both be registered.
Okay, there's another question in the chat box. I was hoping to hear more about IP in the technical sense, meaning intellectual material that is specific to a product, to a company. If I have a specific formula or a highly specific data set that I rely on for developing my product, how do I protect and or market those?
Okay, well, two things. Number one, you may not want to register your IP either with the Copyright Office or the Patent and Trademark Office patent, because what you're talking about here would be the subject of a copyright or patent, not a trademark or service mark. You may want to keep those as trade secrets, because once you register them, they are accessible by the public. No member of the public would be able to use if you register something as a patent, then it's protected for a certain length of time. Generally, I believe it's 18 years. But then after that, it's free for anyone in the public domain to use. So that's why the recipe for Coca-Cola is a trade secret. They never patented that, as is the secret sauce from McDonald's. But but with software, you could copyright that. And then that would, you would have that protection for, I'd have to look it up to see how long. It depends on whether an individual registrant, because I think it's the life of the author plus 75 years, or if it's an entity rather than an individual. And then there's a set period of time, I believe it's 150 years. But you would then, you would have a copyright infringement claim. So, but your work would be part of the public domain. So there's a trade-off between whether or not you want everyone to know how it is you do what you do, and possibly come up with something that is similar but not infringing, or keep it as a trade secret.
Thank you, Mary Jo. Does anyone else have any other questions?
It's Dorothy again. Just one more quick question. So we work with a lot of startup companies. Obviously, if they have something, at what point should they take that step to register a copyright or a trademark? I mean, because they don't really know how successful their business is going to be. How much of an investment are they looking at for these types of registrations?
Right. Well, it really depends on which type of intellectual property you're talking about. If something is copyrightable, say they have software or a certain technique that they use, and that is the subject of a copyright or patent, then they should, right at the outset before they begin doing business, obtain copyright registration for the reasons that I cited before, because if you don't register a period of time, you're going to have to prove your actual damages if someone infringes. Plus, it gives you then are the presumptive owner of that IP. But you have to, and then there's the patent aspect of it. If it's only patentable, not copyrightable, then you're only going to get the protection for 18 years. And then after that, hopefully you've gotten enough of a leg up on the market so that when competitors come in and start to offer the same thing, you'll already have established a lot of goodwill, and you'll be, you'll have the advantage. You'll be way out front. But trademarks and service marks are often, the registration of those is often left till later. People come up with, and businesses come up with names and marks, that include words and or logos early on, and they may not decide to register them until the business is really up and running. You can rest on your common law rights with those for a while. The most protective approach is to register them. And there are, the registration fee is generally $275 per class of goods or services with the Patent and Trademark Office. And then an attorney's time, if you have an attorney, do that as well. Patents can be very expensive. Copyrights, not very expensive, probably the least expensive of all three categories. There's a $45 filing fee, and then the time for the attorney to file the form.
Thank you.
Are there any other questions? If not, we will conclude today's webinar. I would like to thank Mary Jo for being here with us today and for sharing your insights on small business intellectual property. It was very informative. Just a few housekeeping notes. I will be making available the recording of the training on the Wilkes University SBDC YouTube channel, and I will email the link to all attendees today. Also, I will be emailing the link to a post-event survey so that we can determine which of our resources will best suit your needs and what topics you would like to see as training sessions in the future. With that, I would like to thank everyone for attending this training. And if you have any questions, please don't hesitate to contact us at the SBDC. I hope that you all have a wonderful rest of your day, and I look forward to seeing you at future webinars. Thanks.
Thank you.
Thank you.
Bye-bye.
Bye-bye.
Bye-bye.